Hi, this is Richard Chamberlain, and welcome back to the Protecting Your Family's Future podcast. This is episode number 124. Today, we're going to be talking about healthcare directives. We get questions about these documents from our clients sometimes because there's confusion about what they do and what they don't do. The main documents that we're talking about when I say healthcare directives, HIPAA authorization, a healthcare power of attorney, and a living will. Now, a HIPAA authorization is simply a document that appoints people to be authorized recipients of your protected health information. You know that if you ever go to the doctor or hospital now, they won't tell anybody anything about your treatment or your condition without your written permission. So this is that written permission. It's an authorization. You're saying that doctors and hospitals can release information to these particular named people. So when we do an estate plan for clients, we provide them with a HIPAA authorization so that their people can receive information about their health care, their health condition. Now, equally important document is a healthcare power of attorney. This is a document where a person appoints the people who can make healthcare decisions for them if they lose the capacity to make their own healthcare decisions. So you appoint an agent under the healthcare power of attorney and give them the authority to make whatever healthcare decisions need to be made under whatever the circumstances are. Uh, Really, whatever you can do for yourself with regard to healthcare, whether that's making decisions about treatment that you'll have or not have, signing authorizations, releases, consents, anything like that, your healthcare agent can make those on your behalf if you have lost the capacity to make them yourself. Now, one of the things that's important to know is that your agent cannot make decisions about the withdrawal of tube feedings if you're in a permanently unconscious state unless you specifically authorize that power. So that's a decision that you need to make in that healthcare power of attorney to give your healthcare agent or agents that authority to make those decisions for you in that very particular circumstance. Now, of course, we're talking about Ohio law here. And if you're in a state other than Ohio, your state's laws are going to be different to a degree or another. Healthcare documents, healthcare law is very state specific. So if you're not in Ohio, you should definitely consult with an attorney in your state for the laws that apply. Now, the last document that I'm talking about when I mention healthcare directives is a living will. Now, we've talked a lot about wills before in the podcast. A will, when I say a will, that is a last will and testament. That's a document that says where your assets go when you pass away. A living will, on the other hand, is an advanced healthcare directive. It is an end of life decision document. It says essentially, and again, this is under Ohio law, that if you have a terminal condition or if you are in a permanently unconscious state, you don't want to have your dying artificially prolonged. Essentially, you don't want to be put on machines to keep you alive. You want your family and your physicians to allow you to die naturally. Now, there are some decisions to make in that living will, some very important decisions to make about specifics. But generally speaking, that is the point of that document. Now, one of the things that people get confused about is they they want a DNR, or when they sign a living will, they think they have a DNR. Now, a DNR is a do not resuscitate document, and that is an order that is signed by a doctor. A doctor can sign that order for a person after discussing the matter with the person. Generally, they will wait until a person is nearer to end of life. But part of the living will does say that if a person is in a terminal condition or in a permanently unconscious state, that they want the doctor at that point to issue a DNR, a do not resuscitate order. So while the living will is different from a DNR, it does address that. So if the situation arises, the doctor can then issue that DNR order. So healthcare power of attorney, living will, HIPAA authorization, they're all important documents to have so that your wishes are known and so that the people that you want to have information and to make decisions, they can be able to do those things for you if you are not able to do them for yourself. So it's important to get those documents and keep them updated as circumstances change for you. I hope that's helpful for you today, and we'll see you again next week. Thanks.